fixture filing before the goods become fixtures or within 20 days thereafter. So what is the real operative rule here? We know it's purchase money security interest. The second item, the interest of the encumbrancer arises before the goods become fixtures. That's typically the case, so that's not helpful. 3, this is really what needs to be done and what you'd advise your clients to do, is to file your fixture filing before the goods become fixtures or within 20 days thereafter. And it's reminiscent of the general purchase money security interest rule for equipment, where you got to file within 20 days of delivery. And that's what you have to do here. As long as you file your financing statement within 20 days of the oven being installed, you as the purchase money secured party will win. Well, that's in step with the general idea of giving super priority to the purchase money secured party. Okay. But if you're not a purchase money secured party, if you just, you're another bank maybe that has a security interest in this restaurant's equipment, and they go and buy an oven and install it, and you've not only filed your financing statement and equipment, but you've also filed a fixture filing in all equipment as fixtures to cover yourself in this case, and then the restaurant goes bankrupt. Well, who wins? Well, the mortgage holder is going to win, because you're not a purchase money security interest. Assuming that the mortgage was filed before your fixture filing, which is typically the case. But you may have gotten your fixture filing in first. Maybe you were just ahead of the bank. You knew that they were going to buy this property and buy fixtures for it, and so before they had the property financed, you got your fixture filing in. If you get your fixture filing in before the mortgage, then you win. But again, generally that doesn't happen. Okay, so what other exceptions are there? Let's turn to the problems and do some problems and tease out these other exceptions. But that's one of the main ones that I want you to understand, and I've covered a lot of basic concepts. So enough of this lecturing. Let's move into the problems, and maybe we'll start off by looking at this case on page 205, the George versus Commercial Credit Corporation. And this deals with the mobile home. And we have, the question again. This is between a mobile home owner and a bank that holds the mortgage to the property that the mobile home is on. And then the debtor goes bankrupt, and a trustee in bankruptcy is appointed to place the stay over all of the debtor's assets. And so the contest arises between a mortgage holder and a trustee in bankruptcy, which is treated as a lien creditor. And so the question here is whether or not this mobile home has become a fixture. This is a fundamental question, because if it's not a fixture, then the mortgage company has no interest in it and will lose. They've got no interest in it. They only have interest over fixtures and the real property. And if it becomes a fixture, then the mortgage holder is going to win under the first to file or perfect. They've got an interest, and they file their mortgage, and the trustee in bankruptcy doesn't file. Right, so they're going to trustee in bankruptcy arose after the perfection of the security interest, and so they lose. So the question is this mobile home a fixture? And the court says, yes, it is a fixture. Which is a benefit to who? To the mortgage holder, to the banks, to the real estate financiers. But why did the court arrive at that test? It runs through the different tests that we talked about: annexation, intention of the parties, And it really looks closely at the facts. The fact that this mobile home was the wheels were removed. It was put on cinder blocks. It was attached by C-clamps to these cinder blocks. It was hooked up to a sewer. It was hooked up to a well. It was never driven after it was delivered to the property. And so, there's both physical attachment under the annexation test, although you could argue that, all of those connections could be easily removed and unscrewed, all the water and sewer connections, and that you put wheels back on it and that thing is off the property. But the court said, there is, under the annexation test, it's fixed, connected to the real property. Moreover, under the intentions test, which is prevalent in Ohio again, but the intent of the parties was that it would never move again, that it would basically be like any other house on a property. And so the court says, hey, those are the intentions. Let's treat it like a house. Let's say it's a fixture. And so the mortgage company wins. Let's see. Problems. 97. I think we're doing 93. 96 through 99. '96. That's regards statutory lien holders. I'm going to save that for when we meet on Thursday. I want to focus on fixtures. So we go to problem 97. And I'll read it. As stated above, in differentiating among goods subject to UCC filing, fixtures subject to UCC and realty filing, and ordinary building materials subject only to realty findings, the court looks at three tests. Those are the three tests that we are discussed. I guess with one additional consideration is this application or adaptation to the use or purpose to which the realty is devoted. So you might add that as a fourth test. Although I look at it as kind of another wrinkle in the annexation test, and that is the extent to which the personal property, this oven, was adapted, modified, and become part of the operations of the real property, the restaurant. And if you can argue that, it was specially designed and maybe specially modified and installed in a certain way that was demanded by the architecture and the operations of the restaurant, then that is another way to support your argument that it's a fixture. And you could look at it through intentions. If it was so modified, it's obviously the intent of the party that it become part of the restaurant. Whereas if it's just wheeled in and stuck in a corner, and nothing's done to it, then maybe the parties didn't intend it to become a forever part of the realty. So adaptation to the use or purpose of the realty. And then I have a number of examples here. Let's run through them. It's a furnace that heats the building and water. All right, a furnace, I'd say that that's a fixture. Pretty clear. And it becomes, you don't move furnaces around, you install it and it stays there until it dies, and you attach it to the property. Furnace is a fixture. The pipes that carry the hot water through the walls, another fixture. And this is another rule I want you to keep in mind, and that is ordinary building materials. And that's in 9.334. Yes, 9.334A. It says a security interest, the second sentence, a security interest does not exist under this article in ordinary building materials incorporated into an improvement on land. Which means that, you may have a security interest in a construction company's equipment and inventory, which might include bricks, pipes, when they're building a house and putting pipes in and plumbing. But as soon as ordinary building materials, which include bricks for sure, and probably pipes, things that kind of make up the structure of a building, as soon as they are installed, as soon as you lay a brick or weld a pipe, then the security interest is extinguished. The security interest in the pipe or the brick under Article 9. Then it simply becomes realty. So that's another question you could ask yourself that quickly answers the question of priority. On the one hand, if you say it's not a fixture, then the mortgage holder is out of the picture, secured party wins. If you can argue that the collateral is ordinary building materials that have been installed, then the secured party leaves the picture and the mortgage holder has the only claim. Because we don't want people coming in and removing bricks from a house or pipes and removing the plumbing system. No, if it's part of the structure of the house, it no longer is subject to a security interest under Article 9. So the pipes are a fixture. A couch that has been sitting in the living room for 20 years, oh gosh, I mean, furniture is typically not a fixture, but maybe you can make an argument that it is. It was never intended by the parties to be moved, and maybe depends on the size of the couch and wasn't installed, and was it difficult to remove. But generally, if you can pick something up and carry it out with a couple of guys, it's going to be not a fixture, but just collateral under Article 9. 4, a lavish designer bathtub, handcrafted and carefully set in the corner. There you get a stronger, different from the couch. Maybe it's handcrafted and it's carefully, modified to fit in a certain part of the house. Then you get a stronger argument that it's a fixture. Right? And finally, security cameras, tracks, wiring, and equipment for wireless internet access. And it cites a particular case, and this case held that this wireless security system was not a fixture because it could be easily removed, and so the mortgage holder had no claim in it whatsoever. Okay, problem 98, moving right ahead. Monopoly Railway went to Octopus National Bank and asked to borrow money using as part of the collateral its extensive network of railroad tracks, which wind through 12 states. The bank consults you, the track is installed in a total of 117 counties. Must it file a financing statement in each one? Right, so these are fixtures, I think it's pretty clear. These are railroad tracks affixed to a real property, and they're not going to be moved. So they're fixtures, that's clear. And the question is, do you have to, if you're the secured party with an interest in them, do you have to file this fixture filing in every county? And which would generally seem to be the requirement, but there's a special rule under Article 9, 9501B, which says you can just, if you're dealing with a transmitting utility, which could be in electrical poles, right, typical electrical utility, but it also includes railway companies, railroad, then you only have to file in the Secretary of State's office, one place per state. So then you don't have to do 117 filings, you only have to do 12. Okay. That is a very, we're drilling down deeply here. Problem 99. Okay. This is maybe the most complicated problem, and it raises another issue, another rule that I'd like you to keep in mind, and that is the rule of construction mortgages. We've explained the rule of whether it's a fixture or not can make the mortgage holder lose. If it's ordinary building materials, it can make the mortgage holder win. If we have both a secured party and a mortgage holder with competing security interests in the same fixtures, then it's first to file, either the mortgage or the fixture filing. If you're a purchase money security interest in the fixtures, then you will defeat the mortgage holder even if they filed first, as long as you file your fixture filing within 20 days of installation. And now here we're talking about the construction mortgage, which is basically the giving again a super priority to a bank that finances the construction of a building. And it gives super priority to that bank even with respect to purchase money secured parties. So if you have a bank that's funding the construction of a restaurant, and then you have purchase money secured parties selling the oven to this restaurant, and they file their fixture filing within 20 days, so under the general PMSI rule, they would win. But if the bank file that's funding the construction files a fixture filing and indicates that it is claiming status as a construction mortgage, then it will defeat even the purchase money security party. So it's super priority to the bank that finances the construction of a restaurant. And why do we give them that priority? Because their capital is critical for the creation of these restaurants or whatever else they're financing. So we give them super priority. So what are some of the questions here? So it's a bank, Construction State Bank, lends $4 million to Simon Mustache, and has a mortgage on the real estate and all appurtenances and things affixed there too. Now present or after acquired, Simon and CSB sign the mortgage, and it is filed in the proper office of the county recorder. And the first question is the mortgage effective as a financing statement? And the answer is yes, as long as it contains the requirements under 9502. Right? Although it doesn't have to have a statement that it is to be filed in the real estate files, because that is just assumed because it's a mortgage. But otherwise, it's going to have the other requirements. Okay, so the filing, the mortgage is fine for the construction bank. And then during the construction of the apartment building, Simon Mustache bought a furnace on credit from Blast Home Supplies, giving Blast a security interest in the furnace that described the real estate. Where should it file its financing statement? Well, it should file its financing statement in the county recorder's office, wherever the mortgage would be filed. And it should be done as a fixture filing. And they should file a regular financing statement too, to cover the purchaser's equipment in this apartment house. Should do both, but as we saw, furnaces are typically treated as fixtures, so you want to file a fixture filing in the county recorder's office. Is there a technical sentence that needs to be in the financing statement? Yeah, we've run through those in 502, run through them again, that you want to indicate that it covers fixture filings, indicate that it's to be filed in the real property records, and provide a description of the real property. Okay, what else? Why would drafters have added such a requirement? Well, I'm not exactly sure, what the author is asking here, but why does it, require that it has this? I guess it's zeroing in on this question of why do you have to make these particular statements in your fixture filing, and that is it's all a question of public notice. You want to file something, a fixture filing, you need to describe the property, because that's how people are going to search it, and that's how it's going to be indexed according to the real property. And you want to make clear that it's a fixture filing, because then the fixture rules will apply. And then the last requirement, just to remind myself, that it's to be filed in the real property records. I guess just to clarify to the clerk where to file it, to make sure that it's filed with the real property records and not, shipped off to the Secretary of State. So it's all about these requirements, make it easy and ensure that any other competing lenders will be able to find it. Even if Blast files a proper financing statement in the right place before the furnace is installed, will Blast prevail? If Blast files a proper financing statement in the right place before the furnace is installed, will Blast prevail? Yeah, if it's a purchase money security interest, then you should be able to win. However, no. We've got this construction mortgage holder. So even if they file it first, file your fixture filing within 20 days, you're still going to lose to the construction mortgage holder. And where is that rule? Let's find this. It's in 334. Yes, H. 9334H. A mortgage is a construction mortgage to the extent that it secures an obligation incurred for the construction of an improvement on land, including acquisition of land, if a recorded record of the mortgage so indicates. That is, so indicates that it's a construction mortgage. I want to put people on notice so they know that this special super priority applies. And a security interest in fixtures is subordinate to a construction mortgage if the record of the mortgage is recorded before the goods. So there's still that requirement that the construction mortgage holder has got to file before the fixture filing. If the seller of the oven, or the furnace in this case, files a fixture filing before the mortgage is filed, then that purchase money secured party will win. But if the mortgage, so long as the construction mortgage is filed first, construction mortgage holder is going to win, even going to defeat the purchase money secured party. Super priority. What can, here we go. If CSB's interest is not perfected, will blast prevail? Yeah, I mean, if CSB has not filed their mortgage, then Blast is the first to file, then Blast wins. And what can Blast do to ensure itself of priority? Well, you got to ensure that the only way to win is that you file your fixture filing before the construction mortgage is filed. That's the only way to win, technically. But again, there's always this option of subordination agreements. And if Blast, wants to sell these furnaces, and the constructor here, Simon Mustache, the debtor who's building this apartment building, if he really needs these furnaces, and the construction mortgage company decides that those furnaces need to be installed in order for the apartment to be successful and make money so that Simon can pay them back, all the parties see a business interest in giving priority to blast furnaces, then they can enter into a subordination agreement giving blast furnaces priority regardless of the rules that give the construction mortgage holder priority. So that's always an option. But otherwise, you got to file that fixture filing before the construction mortgage is filed. Otherwise, they get their super priority. We've made it through problem 99, and that is the mind-bending law of fixtures under Article 9. I look forward to your questions. You must have them. And you can send them to me by email or make a list of them, and we'll talk about them when we meet on Thursday. All right, look forward to seeing you then.